we've got a technical issue we're working on, so I'm not gonna have y'all start quite yet. If you just hang in there with us. Still don't understand.
Rita, can you hear us?
Yes, loud and clear. Can you hear me?
Yes, Ted, we'll be back in just a moment.
Okay, thank you.
Okay, thank you everyone for hanging in there with us while we got that fixed. Okay, Mr. Cassidy, you're up again.
Thank you, Your Honor. Before I begin, should I just play this as if we're starting fresh and you guys have not heard the previous argument? I know we talked
Please
about
no.
maybe not redoing it, but
Yeah,
Okay.
please
Yeah,
God.
no, I think we're pretty familiar with your argument. So you want to
I think that
how would
there
you
are-
feel about we let Mr. Griffith argue, and then we'll give you time to respond? Or is there something
That's
about
fine.
this case you want to address in particular? Why don't you go ahead and do that? We'll just stick with that.
Yes, Your
Because
Honor. I think
think
it's
his
just
arguments are a little different.
I appreciate it. I think it was a fairly robust panel in terms of questioning. So there's a couple things that I think that I would like to maybe point out a little bit more, if I may.
Yes,
Your Honor,
go ahead.
William Cassidy. Thank you, William Cassidy, on behalf of the appellant, Ideal Image Development Corporation and Ideal Image of Ohio. As the court heard in the case that's traveling with the Stewart case, the Bueno case we just argued, the bulk of the argument is very similar. A couple things that I think is worth pointing out with maybe a couple other nuances than I did in the Bueno case, and that is the context of the issue of exactly why I think it's important to view the distinctions in the various aspects of 685.102 with an open mind in terms of what the legislature meant. And I did point out in the last argument this notion of 685, I said 102, I'm sorry, it's not 102, it's 101, 685, 101, subsection 1 and then 2, where it talks about the section does not apply to any contract, agreement, or undertaking. The last argument, the court was more focused on the issue of whether it was a contract for employment as whether or not it was an undertaking, which is the trial court's alternative ruling. If Mr. Griffin argues about that, then I'll come back on the rebuttal and address that issue if the court would like. But this issue of a contract for labor and employment is a very stark difference than the remaining other components of the contract of the statute. And 2B is the contract for labor and employment. 2C is relating to a contract, agreement, or undertaking relating to any transaction for personal, family, or household purposes, unless such contract, agreement, or undertaking concerns a trust, at least one trustee of which resides or transacts business as trustee in the state. Now, that distinction is what's been picked up in the cases that we cited, as well as in the case that we provided on supplemental authority. And the reason why I think it is important is the cases that we discuss in terms of when you're looking at the statutory intent is you have to look at the totality. Why did the legislature choose one thing in one section and not the other?
Well, Mr. Cassidy, I
Yes, Your Honor.
appreciate that point, and I just want to, and I understand what you're saying there, but let's substitute the word "for" in subsection C for relating to any, or relating to. It would read "for any transaction for." So isn't it possible that relating to just sounds better? Not that there's some deep legal significance to that choice of words?
I don't think so, Your Honor. I think and the reason being is that the legislature is presumed to understand why it's making certain things. I cite it to the case of previously I talked about the Moonlit Waters case, but beyond that, Your Honor, the other case that I think really proves this out. Let me get to it real quick, if I may. It's at page 19 of the initial brief, and it is the Hillsborough County v. NCJ case, and it's from this court, 1992. And it says, where a statute enumerates the things on which it is to operate or forbids certain things, it is ordinarily to be construed as excluding from its operation all those not expressly mentioned. And that piggybacks on the Moonlit Waters case in terms of the express exclusion of the one is the express exclusion of another. And when you read these cases, what they're looking at is not only in terms of different statutes. The courts will apply this and say, well, statute A says X, statute B does not say X, instead it says Y, therefore the legislature is presumed to understand that that narrowing in statute A doesn't apply to statute B. Here you have the very same statute, and not the very same statute, the very next provision in which there is this expansion. And I would posit, Your Honor, that the term relating to any transaction is easily more broad than for labor and employment, because the court could have also said for any labor and employment. They could have used the qualifier any in terms of having the expansion, but they did not. They didn't say relating to, and they didn't say any. And why I think that's important. Yes,
Let
Your
me,
Honor.
or they could have said relating to labor and employment. But let me ask you this. As I'm hearing your argument or understanding your argument, it's your position, and correct me where I'm wrong, that to be a contract for labor or employment, it says, we're going to hire you to do X job, and you're going to work this many hours a week at this rate of pay, and you get this many vacation days, whatever, the terms of employment. And you're contending that that is the only thing that can be a contract for labor and employment. And because this agreement isn't that, it can't qualify as a contract for labor or employment?
I think that might be a bit more expansive than what I'm arguing, Your Honor. I think that
why can't this be a contract? I mean, why is it wrong to say that this is a contract for labor or employment, a contract agreement or undertaking? Why is it wrong to say that?
Well, since you addressed this issue of the undertaking, I will briefly just say, I don't think the legislature meant you can have a contract. Let's say it was a contract for employment. If it's not a contract for employment, if it is a contract for employment, or if then you say it's not, as this court said, the trial court said in the alternative, you can't combine and condense the issue of undertaking to mean all of it. Because if you were to say, well, if it's not a contract for labor and employment, it therefore is an undertaking, it would make agreement and contract superfluous in the statute. You could just say undertaking, because an undertaking is much more broad. And as the appellee pointed out, the very term of undertaking says it's without agreement or without contract. So that's the issue with the agreement. I'll get into it more if Mr. Griffin argues it. But in terms of why it is not a contract for employment, the issue becomes when you read the actual terms, what is it? What does it say? And the employee obligation agreement talks in terms of the negative. Thou shalt not do these things. Not once you're employed, these are the things that you're supposed to do in order to be an employee in terms of where you go, what duties you have, what job description you have. Now, to Judge Atkinson's point earlier in the previous argument, no, I don't think that you necessarily have to have an enumerated checklist of, okay, they didn't say duty, so therefore it's not a contract for employment. They didn't say pay, therefore you're not a contract for employment. I would agree with Your Honor in that regard. However, I do believe that when you look at the totality of the agreement itself, the employee obligation agreement, it makes pains to say this does not change all the other obligations that you have. Under the at-will employment section, it says this doesn't change any aspect of the employment at will. That Ideal Image retains all the rights that it had prior to entering into.
So wouldn't that
this
be the
employee
same?
obligation
Wouldn't that be
agreement.
the same scenario as if there had been a written or oral agreement of employment, and then in my hypothetical, subsequently, the employer decided, well, I'd like to institute an incentive program, so I'm going to have a commission structure, and so let's draft an agreement. And wouldn't it be intuitive and not unlikely or not unsurprising to find that same language that says this agreement doesn't change any other terms of your at-will employment agreement, which would make everybody comfortable. You're still going to get your salary, you're still going to get your paid vacation, whatever, right? So what's the difference? This is a separate document memorializing a condition of employment, just like that. In my hypothetical, a separate document memorializes an additional condition of employment.
The difference, Your Honor, at least in the hypothetical you gave me previously, was that contract also included the restrictive covenant. And it was in exchange for.
So any restrictive covenant,
that,
so I'm not following. So because it includes a restrictive covenant, it's not an employment agreement? Don't employment agreements sometimes include restrictive covenants in them? You can see that, right?
What I'm suggesting is your
You don't think this is an
previous
employment agreement, but you concede that some employment agreements include restrictive covenants. Hey, here's your salary, here's your start date, here's your paid vacation. Also, don't compete with my competitors and don't divulge confidential information, right? So if you just broke it out,
I think in
if you
that
broke that
situation,
condition out into a separate agreement, why aren't both either separate employment agreements for employment or both part of one agreement for employment that's broken into two different documents?
and Your Honor, I think that's the point that I'm ultimately trying to make. If you separate them out, that's what gives the distinction. And I think
What if you
that's
sign
where
them
we
on the
look at
same day?
many top-
Walk in, you say, hey, here's, thanks for coming aboard, or thanks for, submitting yourself to this application process. First, before here's your employment application, which includes you sign off on all, if you're hired, you've already signed this employment application. What if you sign them all on the same day? And it's a separate agreement.
Well,
So it's the same day you sign your employment, one thing that says employment obligation agreement, and it includes your rate of pay, your sick leave, your annual leave. It includes your, your retirement package. And then the HR person throws in front of you another thing that says employment obligation agreement. And it says, as a condition of an offer of employment, you must agree not to compete with my competitors. Would that be also not part of that employment agreement that the employee entered into on that day?
well,
Because it
without
was
getting into
separate piece of paper.
without getting into a potential rabbit hole of whether those two documents can be read together and it creates a one document as some of the cases discuss. I don't know all of the totality of it, but what I would say is this: if you wrote them separately, then one is a standalone restrictive covenant, which the courts, including this circuit, has said that's okay. You can have a standalone restrictive covenant. It doesn't make it a contract for employment. And whether it's a condition of your employment, that's not what 685-101 says. It doesn't say a condition of employment. It says a contract, agreement, or undertaking for employment.
So,
And I
Mr.
think that's the
Cassidy-
distinction that I've been attempting to make. I'm sorry, Your Honor.
No, but this to follow up with Judge Atkinson, if you look at this provision here, how do you reconcile Section 9 of the Employee Obligation Agreement that basically says this agreement constitutes the entire agreement between the parties regarding the subject matter and contains all understanding and covenants of said parties, all previous and all contemporaneous undertaking, statements, agreements, covenants. How do you reconcile that with your argument today?
Your Honor, I would point to the language of paragraph 9 that you just read. And what's
Yes.
important is the language that the entire provision is predicated upon. And it is regarding this subject matter. And what it's saying is there's nothing else between the parties related to this subject matter. What is the subject matter of the entire agreement? It is all about the restrictive covenants. And that is why I think there is a very clear and stark difference between saying this agreement changes. It says this is the entire agreement between the parties related to employment, related to all things related to employment whatsoever.
And
You have to look at paragraph 9.
Well, you have to read paragraph 9 that in conjunction with the paragraph that says nothing contained herein in any way alter the employment at will nature or shall create, suggest, or any. Let's see. In other words, yes. So if you read that, in other words, that provision in 9 that says this is the sole agreement on this issue, then that must be read narrowly. That obviously can't be read the way that you just decided to read it, which is that this must be every single condition of employment. No, it actually says other conditions of employment are not affected by this.
I think I'm saying the opposite, Your Honor. If I wasn't clear, I apologize. What I'm saying is 9 is saying related to the subject matter of this agreement. If you go back to paragraph 2, section 2 of the employee obligation agreement, where you were just referring to the at-will employment section.
Yeah.
What that is saying is it's not expanding the rights. It's saying we're reserving those rights. Those rights as
So what
far
are you
as
saying?
the
How are you saying
employee,
paragraph 9? How are you saying? Please explain how paragraph 9 supports your argument. Yeah.
because paragraph 2 doesn't expand Ideal Image's rights. Paragraph 2 is saying this is separate and apart from our rights as your employer with respect to at-will employment. Paragraph 9 is saying the merger clause is only as to the subject matter of this agreement. The subject
Which is
matter of the
what?
agreement is not the
Which
employee,
is
is the restrictive covenants.
right. The condition this condition of your employee. So the way I reread 9, what's wrong with reading 9 and 2 together to say this condition of your employment agreement is supplemental to any other condition of your
Because if that's what, respectfully, Judge Atkinson, if that's what it was meant to read, that's what it would read. But it doesn't say
No, that is what
it's
it
in
reads.
supplement 2.
No, that is what it reads. It says in the first paragraph, as a condition for an offer of employment or as a condition of continuing employment. That is what it reads. It is a condition of employment, whether you want to concede to that or not. And then, so that is what it reads. So and then I go back to my hypothetical. This is no different than on the same day you show up and you have another document, or paragraph 2 could be referring to an oral agreement with certain conditions of employment, or it could be referring to a written agreement. You still haven't explained why, if this was signed on the same day, for instance, which for all we know it was, or on the same day that orally there's an agreement reached on employment terms, that this is not because it's a condition of an employment and consideration for employment is not an agreement for employment.
Because
Mr.
I
Cassidy,
think
I'm gonna-
the issue there,
Mr. Cassidy, I'm going to let you answer that question, but then you need to wrap up. You're hitting your rebuttal time again, believe it or not. So go ahead and answer.
it's okay.
Yes.
The panel has had a lot of probing questions, and I appreciate it. The answer, Judge Atkinson, to your question is it changes the notion of for employment back to related to or condition of. And that's not what the statute says. I am not in any way, shape, or form suggesting that paragraph 1 doesn't say in consideration for an offer of employment or continued employment. It certainly says that. But what it doesn't say is that this is a contract for employment. And when you read these things together, which obviously the court knows you must, paragraph 2 says this doesn't touch anything having to do with the employment relationship in terms of it being at will. What Ideal can and can't do with respect to that, this agreement doesn't touch. It does in paragraph 9 says only related to this agreement. And the last part of your question, Judge Atkinson, is why doesn't it then become a contract for labor and employment? Because the terms itself make that clear. And even if it was written on the same day, no, I think the cases make clear you can have a standalone employment contract or obligations under terms of an at-will employment agreement, whether it's oral or written, and you can have a standalone restrictive covenant. Because if you read them
all right,
as
Mr. Cassidy.
combining, it doesn't, the statute goes, it exempts the entirety of the restrictive covenant statute, and they could have done that. They did it with banking. Thank you, Your
Okay,
Honor.
thank you. Thank you. Mr. Griffith, are you ready?
Yes, Your Honor.
All right, you may begin.
Thank you, Your Honor. My name is Kevin Griffith. May it please the court. And I practice with the Littler Law Firm out of its Columbus, Ohio office, where I am today. I represent the appellee in this case, Florence Stewart. To try to, for all of our sake, I will try to cut out as much of the argument that's already been had. I did listen to the previous argument, and I have some ideas what the court's interested in here. But let's start with what there's no dispute about. And here, there's no dispute that appellant's sole basis for asserting personal jurisdiction over Ms. Stewart an out-of-state resident is Section 12 of the Employee Obligation Agreement. There's no dispute that the only agreement concerning appellee's employment with appellant at issue in this appeal is the Employee Obligation Agreement. At times, I may refer to that as the EEO or just the agreement. And there's no dispute that under 685.101 and 685.102, Section 12 of the EOA does not confer jurisdiction to the courts of Florida on this out-of-state resident if the Employee Obligation Agreement is a contract, agreement, or undertaking for employment. Here's where the dispute lies. As I see it, appellant is calling the Employee Obligation Agreement a lot of things. And on its brief on page 11, the EOA is an ancillary agreement to employees' employment. Brief on page 23, it's a standalone restrictive covenant agreement. Brief on pages 9 to 10, it's an offer of potential employment. It's also not an undertaking, which appellant asserts would be a misreading of the statute because it's a written contract. Appellee submits that all of these monikers are just torturous red herrings. Let's keep it simple. Let's be clear. Let's just look at the plain language that the legislature used. This Employee Obligation Agreement is a contract, an agreement, and an undertaking for employment. It's all three. It's an at-will employment agreement that contains restrictive covenants. Not unusual in corporate America. Let's take a closer look at the agreement if we can. First, it's titled Employee Obligation Agreement. It's not titled Offeree Obligation Agreement. It's not titled Ancillary Obligation Agreement. It also defines the appellee as an employee in the very first sentence. And it defines appellee as an employee all the way through the entire agreement until she signs it at the end of the agreement under the title in all caps, employee. The first sentence, as we've heard the judges recognized in the previous oral argument, confirms that the document is a contract, agreement, and undertaking for employment. We could all stop here and go home. In consideration for, and as a condition preceding to, an offer of employment from, or continuing employment with. That sure sounds like it meets 685.101 2B safe harbor. But let's go on. Section 2 defines employment relationship between appellant and appellee in detail. It addresses employment rights in Section 2. Quote, employee and the company retain the right to terminate the employment relationship at any time for any reason with or without cause. That includes the appellee has the right to do that as well. Other employment rights are addressed in Section 2. The company retains the sole and complete discretion, a right, to alter any term or condition of employment, including but not limited to employees' hours of work, position, compensation, the company's method of determining employees' compensation at any time for any reason. In doing so is no defense to enforcement of this agreement. Clearly, we're only on Section 2. The subject matter of this document is about employment of an employee. Let's go to Section 3. First sentence refers to employees' special and unique services and how employees' position with the company places employee in a position of confidence and trust with customers, suppliers, and other persons with whom Ideal Image has business relationships. Next sentence in Section 3. Employee further acknowledges that the rendering of services during his or her employment will require the disclosure to employee of confidential information, confidential business information of Ideal Images as defined later in the agreement. This is something the employee is getting. This is a benefit, a right, and it's during his or her employment. A few things about that sentence in Section 3. The subject matter, again, is about employment. And I'm just going to stop right there and say this is directly contrary to what Mr. Cassidy just said in his argument in this case and what he said in his argument in the Bueno case. He's saying, quote, nothing talks about the terms and conditions of employment in the employee obligation agreement. Truly and completely a restrictive covenant agreement. The subject matter is all about restrictive covenants. We just went through the first three sections, and we're seeing all kinds of references to employment. And the during employment reference, or in the course of employment reference, and the restricted period references, those are very telling references. It's what the party's expectations are while the appellee is employed during her employment, in the course of her employment, during the restricted period. The restricted period includes her employment in 2 years thereafter, okay? There's over 20 similar references to during your employment or in the course of employment or restricted period throughout the agreement. Why does that matter? Because it confirms that the subject matter of the agreement is about employment. This in turn confirms how the employee obligation agreement is a contract, an agreement, and an undertaking for employment. In the face of the agreement's plain language, appellant insists that it's a standalone restrictive covenant agreement. This is on page 23 of their brief. Standalone restrictive covenant agreement that merely arises out of or is related to appellee's employment, but this is not itself a contract of employment. This is linguistic dancing at its best. Section 3A expressly defeats this assertion. There's a sentence in the fourth line from the bottom of section 3A. Quote, employee agrees these covenants are a material inducement for the company to employ and or continue to employ the employee. Judge Kuzman just hit on the other section that matters here. Section 9 also defeats appellate's assertion that this is some kind of standalone restrictive covenant agreement, and that's the only subject matter of the agreement. The first sentence in section 9, this agreement constitutes the entire agreement between the parties hereto regarding this subject matter and contains all undertakings and covenants of said parties. I could go on. We've been through a lot of this already. Suffice it to say, if you follow wherever the contract is saying during employment or in the course of employment or restricted period, there are things going on in the relationship that the company expects and the employee is supposed to do during her employment. Now let's turn to what Circuit Judge Farfanti said in his second amended order, granting appellee Florence Stewart's motion to dismiss. That was on September 17, 2021. In the second full paragraph of his order, he found, here, the parties executed the agreement. Here's the language we keep saying at the beginning of the first sentence of this thing. In consideration for, and as a condition preceding to, employment from and continuing employment, citing to Exhibit A to the complaint. Despite plaintiff's assertion that the agreement is not for labor or employment, the agreement is the loan contract between the parties referenced in the complaint and provides that Ideal Image retains the sole and complete discretion to alter any term or condition of employment, including but not limited to employees' hours of work, position, compensation, and the company's method of determining employees' compensation. Moreover, the agreement contains other provisions regarding employee inventions and the use of voice recordings. Let's take a quick look at those. If you go to section 4, and it's on the 5th page of the agreement, which unfortunately doesn't have page numbers, but there's two lengthy paragraphs and subparagraphs about employee inventions. Very specific description of what they are, what employees' rights are as to them or no rights as to them, and what the company's expectations are as to employee inventions, with repeated references to during and after the employee's employment, his or her employment. Let's look at section 5, recordings. First sentence, employee hereby consents to allow company group, any related entity, or its designee or assignee to audio record employee's voice at any time during the course of employment, okay? But that's not a restrictive covenant. That's the obligation the company's asked her to agree to as it relates to recording her voice. So the judge below was on top of this analysis, and he just gave 2 examples. Not surprising he didn't try to go through the whole thing because busy trial court judges don't have that kind of time to do that, but he had it right. And then he concluded with, the court finds the agreement is a contract or agreement for labor he skipped the word or employment, that was a typo, and cannot serve as the exclusive basis for personal jurisdiction over defendant pursuant to 685-101 and 102. Even assuming the contract for labor and employment, even assuming it's not a contract for labor and employment, it's clearly an undertaking for labor and employment, and thus falls squarely within the safe harbor. It certainly looks like the trial judge got this right, and he interpreted and applied 685-101 and 102 without error to section 12 of the employee obligation agreement. I think maybe the last couple of points I'll make would be all of this case law we keep talking about, none of it squarely addresses the issue before the court. This is, to my knowledge, a first impression issue in the state of Florida. Judge Farfanti below has issued 2 decisions on this. They say the same thing. You've noticed we didn't cite any cases that say, here's a case right on point, because we didn't find one. The cases that the other side has cited, we could go through them and distinguish them, et cetera, but none of them squarely address the issue before the court today. I think lastly,
Actually, there's very little case law on this at all.
correct. And Square Ring noted that in a footnote, and as of 2018, that there wasn't really any case law interpreting the issue that we have. Certainly not a decision that's interpreting the issue that we have before the court today. Final thought in my mind is, when you review the plain terms of the employee obligation agreement and the overall facts and circumstances of its offer, acceptance, and obvious employment purpose, the subject of matter of this agreement is employment. It's obvious, and Section 9 destroys their argument about an ancillary agreement. If you look at the circumstances of offer, acceptance, and obvious employment purpose, this court can properly conclude that but for the employee obligation agreement, appellant would not have employed Ms. Stewart. This logically leads to the conclusion that the employee obligation agreement is a contract agreement and undertaking for employment. So unless the panel has any questions or issues they'd like to discuss, I urge this court to affirm the circuit court's decision below as correctly decided, and also give strong consideration to the motion for attorney's fees that Ms. Stewart has pending before the court.
Thank you. All right, Mr. Casting, you got 2 minutes.
Thank you, Your Honor. First of all, with respect to the provisions in subsection 2 that Mr. Griffin referred to, there again, it's saying what the company retains, not what the contract is giving it. So I think that in and of itself shows this is not a contract for employment. The issues of what Mr. Griffin is ultimately saying is that all restricted covenants that have anything to do with employment would therefore be excluded. And I go back to 685-102, 101, not just in terms of subsection 2C relating to any transaction, but also subsection E that says, to the extent such contract agreement or undertaking is otherwise covered or affected by 655.55, which is the banking statute, it's excluded in the safe harbor. If what the legislator truly wanted was all agreements related to restricted covenants having anything to do with employment, then it would have said covered by or affected by section 542.335. It didn't say that. And this is an expansion of the particular purposes of this statute.
Even if there were some covenants that, as you say, relate, that are the restricted covenants that relate to employment, even conceding for the sake of discussion that some of them may not fall within the ambit of the exception here. The agreement at issue says the employee agrees these covenants are a material inducement for the company to employ or continue to employ the employee. Sounds
But
like
there's no
for
contention.
employment.
Judge Atkinson, that again goes to the issue of consideration rather than what's the point of the underlying agreement. The consideration doesn't, the 685-101 does not say in consideration for. It says
Oh.
for. If it was in consideration for, it would be that. As for the attorney's fees, just briefly, we briefed that. It's very clear that when you're dealing with issues of jurisdictional aspects, then attorney's fees are improper. And I don't
Okay,
think
Mr.
that that should
Mr.
be addressed
Cassidy,
otherwise.
Mr. Cassidy, your time is up. Sorry to jump in
Thank
and
you, Your
cut you
Honor.
off, but we've given you a lot of time. I know we've asked a lot of questions too, but I need to be fair to everybody. So thank you both. I guess we found this to be an interesting case. So thank you both,
All right.
and we're ready for our next case.